Hi, I'm Bill Almond, President of the Adhesive and Sealant Council, and welcome to the latest edition of our monthly podcast. Each episode, we'll be discussing some of the biggest issues and trends affecting our industry and look at what this means to our membership. To make sure you don't miss out on future shows, hit the subscribe button. We hope you enjoy the program. Welcome to the third Connected to ASC podcast of 2023. Today's episode continues our focus on sustainability and specifically on greenwashing. As a larger percentage of consumers desire greener and sustainable products, manufacturers are investing more in this area to meet the demand. However, with increased focus has also brought increased risks. A 2022 ASC survey found greenwashing, or the risk of greenwashing, among the top 5 challenges or barriers preventing adhesive and sealant manufacturers from adopting more sustainable products. My guest today is Tanya Nesbitt, partner at Thompson Hine LLP.
Hi, Bill. Thank you so much for having me.
It is a pleasure to have you on today's podcast. So, Tanya, tell us a little bit about your background and also areas of expertise at Thompson Hine.
Certainly. So as you mentioned, I am a partner in the environmental practice at Thompson Hine. And I often get the question about what that means. I think people oftentimes find environmental law a little opaque, which I find somewhat intriguing because I think in many ways environmental law has very practical application really to everybody's life. But my expertise has mostly been in the litigation and compliance space. And so I focus on most major environmental statutes like the Clean Water Act and other statutes like the Endangered Species Act, National Environmental Policy Act. My litigation approach was informed really by my prior government service with the Department of Justice and the U.S. Attorney's Office. And there I gained an expertise in working on permitting and other natural resources issues, focused primarily on public lands. And so I have quite a background and history of working with a great number of federal agencies and responding to agency actions and adjudication. And so some of my expertise also necessarily involves administrative law. My service approach to litigation and compliance work is to control cost, obviously, and manage cases in such a way that there's a predictable outcome, predictable expectations in terms of case management, and that hopefully would generate a resolution that is quick for our clients and minimizes the disruption sort of associated with business function, which can often come about due to environmental problems.
Yeah, and I think it sounds like your background definitely comes in handy helping companies with this specific issue as well. As you and I talked before we got on the podcast today, I've worked with a lot of your colleagues there at Thompson Hine on a variety of issues and really enjoy working with the firm quite a bit. They're a big resource to ASC as well as to our industry. So let's get back to greenwashing a little bit. Can you define or broadly speaking what greenwashing is and where and how it did first come about?
Certainly. So, I'm going to give you the best consensus in terms of a definition because there is no national, international consensus. And I think that when we look sort of at greenwashing from a comparative approach and look across the pond, we see that our neighbors are perhaps further along in trying to formulate a definition and from that sort of define a regulatory scheme. But at the moment in the United States, we generally think of greenwashing and believe it has occurred when an entity has misrepresented the environmental benefits of its product or misrepresented its ESG credentials. And so greenwashing, like ESG, was born out of the really social movements centered around the demand for more environmental accountability. A number of movements that created sort of the legislation that we have now, right? Earth Day and the Clean Water Act of the 70s. And I think companies and consumers being more concerned about our environmental stewardship. And so in the 1980s, an environmentalist by the name of Jay Westerfeld coined the term greenwashing, really to express displeasure, distaste for the hotel industry, save the towel movement. And so that movement was centered around, or marketed really as having environmental benefits related to the reduction of waste and water consumption through the reuse of towels. And he felt, upon closer examination, um, the real impetus for the movement was just based on minimization of costs associated with washing the towels and not really environmental stewardship. And so he used the term to really highlight that disconnect or deception.
So this term has actually been around for a while. It sounds like we talk a lot about how the younger generations drive so much of policy and the way companies react to today. And looking at Gen Z, I mean, is it true that Gen Z is driving some of the attention or more the demand on greenwashing, or is that a myth?
So, defining Gen Z as the generation born between 1997 and 2012, I think that there's definitely been studies. I think McKinsey did a study in 2018 that definitely indicated their attitudes suggests that they are the type of consumer that is more willing to demand accountability in product and services from companies, and certainly the type of consumer that wants to see companies take a stand and display some investment. And I think that kind of goes beyond environmentalism. I think also here we see those attitudes from Gen Z. Obviously, the acceleration sort of ESG and that movement sort of demanding also more accountability. And then we see the urgency needed to act to stabilize climate change, and the science there indicating that action needs to be taken swiftly. So I think it's all of those factors aligning, I think, to make greenwashing more of a concern and more in the forefront of the minds of today's consumer.
Yeah, yeah, and I think as you mentioned, Tanya, the data certainly bears that out. The conference, sustainability and packaging that I attended last week, there was quite a few studies and data that bear out exactly what you said about the younger generations, but also just in general, I think more and more consumers are starting to expect some more sustainable products and concerns about greenwashing are on the rise. Looking at the company level, in your perspective, where are companies most vulnerable to greenwashing lawsuits? Is it their advertising, their sustainability reports, all of the above? Well, what do you think?
All of the above. So it's really any place in which where an environmental benefit claim is being made, and so that could be on your social media, right? A lot of companies today use social media platforms to advertise and market their products. It could be in your SEC disclosures, right? We've seen lawsuits brought by investors under SEC regs for misleading statements that were included in SEC disclosures, particularly in the bioplastics industry, and we still have pending cases in federal court in New York on these particular types of claims. So I think that companies certainly have to think more broadly. Certainly, the claim itself could be on the product, right? There a number of industries, particularly bottle manufacturers, that place claims on the products themselves. So it can be on the product or the product's packaging. We have to think of where the statements are made, and also think of it from the consumer's perspective of how they are confronting, whatever the item being sold is. And particularly for companies who offer services, I think they also have to scrutinize sort of how advertising is being done. And so in some instances, we've seen cases where the benefit claims were on the consumer's bills, right, for those particular services. So really any place an environmental benefit claim is being made is really going to be vulnerable to potential greenwashing
Yeah.
allegations.
Yeah, and I'm not aware of any notable greenwashing case against an adhesive or sealant manufacturer. I think some of your research has found that to be true as well. Is that right?
Yes, it's not yet is how I
Yeah,
would prefer to answer that question.
yeah,
But we're seeing suits in adjacent industries like bioplastics being one, for sure, and there are obviously a rash of greenwashing cases sort of in the regarding plastics and sort of recyclability of plastics and the circular economy as well, which I think um, probably is leading the pack right now in terms of greenwashing allegations. But we're also seeing a lot of cases begin to creep up in the utility space, right? Because I think we're at an interesting time politically where there's going to be a lot of federal money deployed to implement things like clean tech, green energy, and so a lot of fossil fuel companies now are trying to make that turn and are beginning to market their services as green. And so, what does that really mean? Is it deceptive? Is it misleading? And we're seeing a lot of service providers, things that we don't ordinarily think of as products, right? They're facing greenwashing allegations as well. We're seeing it in food. We're seeing it in clothing. So it's a wide array of industries that
yeah,
are faced with this challenge.
yeah, absolutely. And again, that I know packaging is among those industries that are being targeted. Some rightfully so, and some that may be a little bit less warranted. Can you think of a case where a lawsuit was brought against a company and the company actually prevailed in their defense?
Yeah, so I guess what's interesting here is we're unfortunately getting a lot of decisions out of state court first, and so obviously that does not sort of guarantee consistent application across states. So you're formulating sort of a patchwork of decisions, and we don't really have a great deal of predictability at the federal level. Although we do have sort of the green guides as the leading form of interpretive guidance, and we can delve into that a little bit more. We are seeing companies be very aggressive, or I should say defendants really being very aggressive in terms of trying to either remove actions to federal court that have been filed in state court on the typically state consumer protection statute. Uh, and also, if that attempt is not successful, then trying to move to dismiss for jurisdictional issues under lack of subject matter jurisdiction under 12b1 or failure to state a claim under Rule 12b6. And for your audience, I'm referring to Rule 12 of the federal rules of civil procedure. And typically, states have adopted the Rule 12 equivalent for states. Typically is going to be the same or substantially similar. So far, Coca-Cola has been very successful both in state and federal court in dismissing claims brought against them. The first case dealt with advertising and marketing materials as well as social media that had environmental benefit claims associated with the company's goals. There, the court said that statements about the company's intent or desire to be more sustainable by a certain date were really just aspirational corporate ethos and not specific promises. And so it wasn't found to be a violation of the State Consumer Protection Act. Furthermore, the statements in that particular case were not tied to a specific product or service such that they could make out an underlying claim under the State Consumer Protection Act, because typically to find a hook under that statute, you have to demonstrate some misleading statement or deceptive action or practice tied to a product or service. And so if the statements are just generally about the company desiring to be carbon neutral by 2030, that's not tied to a specific product. The other example regarding Coca-Cola sort of dealt with its recyclability claims, this time tied to a specific product. The court there relied on the plain meaning of recyclability to make a determination that it meant that not each bottle or product necessarily would be recycled, but that it was capable of being recycled. And there, the federal court, this was out of the Northern District of California, which is referred to as the food court because they see such a high volume of these lawsuits. The court there relied on the green guides as interpretive guidance of how recyclability claims should be marketed and what a reasonable consumer would expect when that term is used, and felt that plaintiffs' allegations weren't reasonable under sort of a plain meaning of the term. We are getting some decisions, perhaps not as quickly as we would like, but we're beginning to get some guidance. And again, I think what is key here too is that the courts, even though the green guides are not law or regulation, courts are relying upon them as sort of the leading interpretation of how to market environmental benefit claims.
That's really interesting. And when we're thinking about mitigation measures, and you had a great article that talked about some mitigation steps that companies should consider. And I'm going to make this available to our members so that they can read it in its entirety. But a lot of companies are trying to do the right thing on their sustainability journey. Yet, of course, we still have some cases brought against companies. Share with our listeners, Tanya, if you would, some of those mitigation steps that companies can take to minimize the risk of a greenwashing suit.
Well, the first is you can't sit on the sideline. I think that this is undoubtedly a very uncomfortable area because it is going to be new or feel new for most companies. And the landscape is changing rapidly. Unfortunately, the regulatory process here is going to take some time. It's going to take the FTC quite some time to produce new guidance that is, I think, more relevant for where the science is today and also for what the consumers expect today. And so we're going to get, at least it's my expectation, we're going to get more judicial opinions on many of these issues before the FTC can get its guidance out. And so every day in the interim, we're seeing a new lawsuit filed. Things are changing and shifting rapidly. And so it's going to feel uncomfortable and maybe more natural to wait. But unfortunately here, doing that creates liability. And so you can't sit on the sideline. The second is you have to consult a lawyer to assist with the review of advertising and marketing materials. And I think historically, perhaps marketing and the law department maybe didn't have much overlap, or you saw each other maybe once a year doing a general due diligence review. But those functions now need to be more aligned so that a lawyer is reviewing all of the benefit claims in any really form, if they're in your disclosures, if they're on your website, if they're on social media. And that needs to be an ongoing sort of reoccurring review that is aligned with all of your typical due diligence functions or audit functions. And so that has to be something that becomes more natural and routine. The other is you have to think about greenwashing from both a defensive and an offensive approach. And so defensively, you're going to want to collect data for the claims that you're making and understand where perhaps data is not available, so you know sort of where the gaps are in your advertising or your marketing materials. And you're going to want to have that data verified, perhaps by a third party, to make sure it is accurate and understand sort of the integrity and the veracity of the information or the data that you've collected. And so that approach, I think, is critical because having the data goes into obviously the ability to substantiate the environmental benefit claim, which should also be part of your marketing and advertising. And it's important because it can prevent further litigation. There are times where plaintiffs groups will ask for substantiation before bringing a claim, and so you might have the ability to even prevent litigation entirely. But that data then also, if you do get sued, is going to be important because you're going to need that to hold plaintiffs essentially to their burden of proof when they attempt to argue that your benefit claims were misleading or deceptive for whatever particular reason. The other mitigation tool is obviously, speak the truth, but speak the whole truth. And so, if you're zero waste to landfill claim only means that 80% of the waste is diverted. Well, that's something important that you should inform the consumer about and indicate what is happening with the other percentage, and also disclose whether there greenhouse gas emissions associated with the other percentage that is not being diverted from a landfill. And so that those inquiries and that analyses sort of indicate as well how you would present the claim to the consumer. So I think being more thoughtful, certainly in how the truth is presented, is certainly very important and part of mitigation.
Yeah, I think there's a really useful mitigation suggestions there to help avoid a case. Finally, Tanya, what do you think is the future of greenwashing cases? Will they expand beyond the state level to the federal level? And I know you kind of touched on this earlier in our podcast today. Where do you see greenwashing cases going?
Sure. So my two observations would be that first, I think we're going to see more enforcement on the federal level, and we're already seeing that. So the SEC has created a climate and ESG task force, which is housed in its enforcement division, and part of their responsibility is also to investigate whistleblower complaints. And so we're already seeing referrals being made about major companies who have allegedly committed this practice. And then the second, obviously, is within the federal enforcement point, is that the FTC obviously is contemplating a rulemaking on the green guides and giving them the force of law. Even if that doesn't happen, I do think that we are going to see, I think, more guidance on sort of hot button claims related to climate change and sustainability, things like carbon neutral, net zero, sort of what do those terms mean and how should they be marketed. But I think overall, I think the FTC also is going to be more active in its enforcement docket with respect to this practice. And the second point I would make just about sort of where the future of the case law and the cases are heading is that I think as we have an administration now that is very focused on a clean energy agenda and also things like environmental justice. And I think as more money is going to be deployed for those types of projects, we're going to see some conflicts in communities where perhaps groups are saying, yes, this project may be marketed in a way that is misleading, or maybe the project has environmental justice concerns or considerations that weren't taken into account. And we're already beginning to see litigation on the state level. I think it's just going to increase on the federal level, but we're going to see the intersection of environmental justice, greenwashing, and nuisance claims. And I think that that's going to push ESG sort of in a different direction a bit, because for me, greenwashing is really the E, S, and G in ESG. And so I think we're going to see more dynamic and interesting cases as we determine sort of where are we going to put our clean energy projects, and which communities are sort of going to bear the brunt of some of that, and how we can make it sort of more equitable.
Yes, absolutely. Yeah. Well, Tanya, this has been very insightful. Really appreciate your time and expertise on this topic today. It'll be really helpful for our members as we better all understand greenwashing and how to avoid it. So thank you so much for being on the podcast today.
Thanks for having me, Bill.
For more information about greenwashing defense and litigation, visit thompsonhine.com. And also, if you're interested in more about ASC's role on sustainability, visit our website at ascouncil.org. Tanya, again, thank you so much. Thanks to all of you who tuned in. We hope you enjoyed this podcast. Make sure you like and follow us so you don't miss out on future shows. Bye for now.